Day. It's our first, oh, welcome everyone to our first Path to Ottawa event on faith and environmental peace building. This is Sulha for Soil, integrating Islamic peacemaking and environmental justice into family dispute resolution and land disputes, that sort of thing. So I'd like to start I'll introduce myself quickly and then our organization, of course, and what our conference is about and the path to Ottawa. I'll let our excellent guests introduce themselves, but I'll start. My name is Elizabeth Hassami. I'm a faculty lecturer for Johns Hopkins University. I'm also the co-chair of the Law Interest Group for the Environmental Peace Building Association. And NPAC or NPACs is a global multidisciplinary network that brings together researchers, practitioners, decision makers working at the intersection of environment, conflict, and peace. We advocate for in the field by promoting research and policy innovation, building practitioner capacity, and fostering collaboration across sectors and regions. Through initiatives such as conferences like our upcoming conference, interest groups, webinars, and peer-reviewed journal, a peer-reviewed journal. NPAC supports knowledge exchange and professional development amongst its really growing international membership. So this is our fourth conference this year, which is really exciting, in Ottawa, Canada. And it'll take place, so everyone knows, between June 16th and 19th at the University of Ottawa. And it'll really bring together environmental peace building practitioners from around the world to share insight and some of the most recent scholarship in this field. So we're really excited about that. And what Path to Ottawa is, and I want to make sure I have the exact definitions here. It's a global series of consultative events leading up to the conference, such as this one, that feature events with NPAC's partners covering various themes and recent scholarship within the field of environmental peace building. And now I'd like to turn it over to our first guest, Imam Ibrahim Hussain, a recognized faith leader and pioneer in the first global media. Anyways, I'll let him introduce himself, as I said. So anyways, Imam Hussain, if you'd like to take it over and start your presentation now.
Thank you, Elizabeth, and a warm welcome to everyone, and good morning to everyone, or good afternoon, depending on the time zones that you're uh, joining from. Thank you so much, Elizabeth, and thank you to everyone for joining. I think there are going to be people from various time zones. Just a bit about myself. So I've been working as a Muslim faith leader and imam in the United Kingdom and in Canada, in particularly, for 15 years now, and my work is focused highly on um, dispute resolution, Islamic peacemaking, the term Sulh, which is referred to and defined as conciliation, reconciliation, restorative justice, peacemaking. So I've had the pleasure of also um, working with lots of Muslim families in Canada and across the world, and I work for the Toronto court roster as part of the Ontario Mandatory Mediation Program. In addition to that, I also am a member of the Toronto Commercial Arbitration Society and the Vancouver International Arbitration Centre, and I also am a fellow of the Chartered Institute of Arbitrators. But my passion and my focus is to really educate not only people from my faith, but people from other faiths and backgrounds about the importance of the Islamic origin of Sulh, which is known as peacemaking or conciliation. I want to start today not with a theory, uh, but actually with a reality that I have witnessed repeatedly in my practice. For many families, land is not just an asset, it's actually an identity. Uh, it is belonging, and it is the physical anchor of family legacy. However, when we see that when that land becomes contested, especially across borders, it can tear families apart for generations. In my work mediating disputes for British and Canadian expatriate families with ancestral land in Punjab, Pakistan, I've actually seen a painful pattern. These are often families who left the subcontinent decades ago. Meanwhile, back in Pakistan, the land sometimes left in the name of an ancestor who passed away in the 1960s became vulnerable. And over the decades, I've seen cases of outright land grabbing, illegal occupation, and unauthorized transfers. But the most heartbreaking part is not just the financial loss, it's actually the severed family ties. I've also had the opportunity to mediate cases or disputes among disputants where cousins in London, United Kingdom, and Toronto, Canada, have not spoken to their relatives in Punjab, Pakistan for over 30 years. And the disputes that consisted only of a few acres of land, ancestral land, had poisoned entire family networks. The trust was gone. Litigation had dragged on for so long that the original disputants had passed away, and the conflict was inherited by their children who barely knew each other. Another thing that I have witnessed as well is that when these disputes, when these disputes, drag on for so long, um, what happens is, the children of the landowners, and I'm talking about in particularly, um, landowners whose children reside in Canada, in Pakistan, America, in the Western Hemisphere. Not only do they have no interest in this land, despite the heritage of that land and despite the connection that the land has with them, uh, not only do they lose interest in the land, but also there is an element of distance that then exists between uh, the family members and these particular children uh, who think that the parents, are going through some mental health issues just because of the fact that their parents are stressing over, this land that belongs to them. In other words, the children are not able to really understand why the parents are so fixated um, about this land. And that's because they do not realize, or a lot of the times the parents have not even openly discussed how this land grabbing has, um, how it has, been constituted, and particularly when it results in talking about their uncles, uh, whether it's paternal or maternal, they obviously do not want to talk about certain things that have happened because they don't want to, um, make the children see how their own blood members or their own blood relatives have, um, taken such measures to, harm their parents. So that's why we see there's a distance between the parents and the children. And this is all through these land disputes and this land grabbing that exists. If you ask me, in these cases, in these disputes, the hardest part was not actually the legal complexity. The hardest part was actually getting the parties to even consider conciliation or mediation, because the bitterness was so deep, the sense of betrayal was so profound that the idea of sitting down together seemed absolutely impossible. One family elder in the UK once told me that I would rather burn the land than see my cousin benefit from it. And I've also witnessed firsthand incidents where, for example, the nephew has not attended the funeral of his uncle just because of a dispute that had existed regarding some land, and the nephew alleges that the uncle, um, you know, took part in some land grabbing or was not fair in distributing the land, or the uncle, for example, for was holding on to a piece of land after his brother passed away, and just because of this, a dispute like this, we see people not attending funerals, whereas in our theology we are taught the Holy Prophet, peace be upon him, and his family clearly indicated to us that the right that a believer has for his fellow believer is that you have to attend their funerals, you have to visit them when they are sick. In other words, people have stopped even following the obligations of our faith because of, um, the conflict, that comes forth from these types of disputes. And that's why this is the context that I bring to this discussion, to our discussion today. And for years, the path forward seemed blocked. But recently, there's some good news to share with you that we have actually seen a shift, and actually a very big an optimistic reason for hope. I just want to define the term sulha, which is an Islamic principle of conciliation. Before I go further, let me just ground us in the framework that I particularly use. And the approach is actually rooted in sulha, which is an Islamic principle of conciliation. Sulh is often translated simply as mediation or settlement, but that misses its depth. Sulh or sulha is distinct from both litigation and conventional Western mediation in three fundamental ways. Now, you can pronounce sulh like sulh, or you can pronounce it as sulha. The beautiful thing about Islamic theology or the Arabic language is that obviously in the Arabic language it's pronounced sulh, but in other languages such as the Urdu or the Punjabi language, the term sulh is pronounced as sulha. So sulha is a preferred state. I just want to quickly go over the first fundamental way of how sulha, um, different compared to conventional, Western mediation. The first thing is that sulha is a preferred state, not a fallback. Muslims are mandated and they are commanded by God Almighty, Allah Almighty, to always choose sulh as the first step in, finding, natural justice. So it's not a fallback. In fact, in Islamic tradition, sulh is actively encouraged as a superior outcome. The Holy Quran instructs that conciliation is best or reconciliation is best. Chapter 4, verse number 128. Sulh is not a concession made because litigation is too expensive or time consuming. It is actually a positive that restores what litigation often fractures: relationships and communities. Um, in my publication, I noted that how one of the great caliphs um, guided the community by explaining how adjudication leads to rancor, and he instructed the judges to always steer the parties towards sulha, towards conciliation, because adjudication leads to rancor, as we see often when judgments are issued, that there's a lot of rancor, there's a lot of not everybody's necessarily happy. In fact, many times, both parties are not happy. The disputants seem that the judge did not entirely rule in their favor, and this is why it is important for us to realize that um, peacemaking brings forth a very important element that helps us to really mend society. The second distinctive element of sulha is that it is justice orientated, not merely interest based. Conventional mediation often focuses on identifying each party's interests and finding a mutually acceptable trade-off. Sulha certainly considers interests, but it begins with a framework of justice, in Arabic known as adl, and restoration, islah. The question is not simply what can both parties agree to, but what would constitute a just and honorable resolution that aligns with principles of fairness, accountability, and dignity. I remember I was part of a dispute, and um, again, this was regarding one family, uh, and one group of the family who were controlling this piece of land in Pakistan, they were using the fact that two brothers back in the UK had some serious, you know, issues amongst them, and they were not talking, and they were using that as leverage to say that, okay, well, we will give you your piece of land, but your brother, we're gonna keep looking after the land that belongs to your brother because we have been appointed by your honorable father as custodians of this land. And I remember when I had to come up with some ideas or some options. So when we were generating options, the best option that I came up with was that I eventually went and met with the one of the two brothers who had some issues between them, since childhood, and I managed to convince that brother that, you know what, are you okay with allowing your elder brother to kind of get access to the land from these other relatives of yours. And he agreed despite the fact that he had issues with this brother, because ultimately, um, he realized that he was also, in agreement to the fact that these people were, controlling the land, for so long, despite the fact that they did not really have the jurisdiction to control the land. So it's interesting to see that when Sulh allows a process that is, which is just and more importantly fair and honorable. It's not just about what is the interest of the parties. And the third distinctive element of Sulh is that it is holistic. It does not separate the legal dispute from the spiritual, emotional, and relational dimensions. A land dispute is not merely a property matter to be resolved by a court. It is a rupture in family ties, a test of character, and for observant Muslims, a matter of accountability before God. Sulh addresses all of these issues simultaneously. Now, we also, as Muslims, believe in our theology that we have, references in our tradition that, if we, forcefully take over a piece of land, then that land will be a means of our destruction in the hereafter. So, there's references to this in our theology. So this is why, land is what we refer to as an amana. It's something that we are trusted by God with, and especially when we're talking about ancestral land, but not just ancestral land. We're talking about land, which is agricultural land, land that families depend upon, and land that has to be utilized in its best way possible, so that not only can the landowners benefit, but also the community can benefit. That's why even as landowners, we have to every year also donate 2.5% of the earning from that land to charity, to people who are needy. So there are lots of responsibilities that come with this land. Um, and this is why Sulh, this is how Sulh is, from these three distinctive elements, this is how it's fundamentally different from litigation or conventional Western mediation. Litigation obviously narrows the dispute to legal rights and remedies, often exasperating hostility. It also differs from conventional mediation models that may treat cultural or religious dimensions as external factors to be managed, rather than as the very foundation of the process. Drawing on this principle, I have developed an actionable framework for Sulha-based conciliation in complex multi-jurisdictional land disputes. And I want to share the four pillars that structure my work. The first one is acknowledgement of harm and restoration of dignity. In the cases that I handle, the legal dispute over land is almost always layered on top of profound emotional and spiritual harm. A family member may have been forcibly removed from land their grandfather tilled. Another may have been falsely accused of theft. These wounds are carried for decades. Before any discussion of boundaries or financial settlements, the process must create space for acknowledgement. This is not about assigning blame, but about validating the experience of harm. I have seen cases where a party's willingness to engage in conciliation shifted entirely after they were simply heard, after someone acknowledged that what happened to their family was unjust. Restoring dignity means ensuring that no party leaves the process feeling humiliated or coerced. In Sulh, the outcome must be one that each party can accept with their head held high. The second pillar is addressing power imbalances. These disputes are rarely between equals. One common pattern I see is absentee owners, families in Canada or the UK or the US, versus local relatives who have remained on the land for several generations, and the local party may have physical possession. Agricultural knowledge, and established community ties. The overseas party may have legal title, financial resources, and the ability to pursue litigation across borders. So each has a form of power, and neither is helpless. But when these powers are unacknowledged and unbalanced, genuine conciliation is absolutely impossible. My framework explicitly maps these power dynamics at the outset. What I do is I identify the sources of leverage each party holds: legal, financial, physical, relational, and then structure the process so that no party can use their power to coerce or dominate. Sometimes this means holding separate caucuses. Sometimes it means bringing in neutral experts to verify land records or agricultural value. Sometimes it means sequencing the conversations that that the more so that the more vulnerable party has support before engaging directly. The goal is not to equalize power artificially, but to create conditions where neither party can impose their will unilaterally, where both must come to the table genuinely and in good faith. The third pillar is integrating spiritual and family identity. For the families I work with, land is not an asset class. It is ancestral soil. It is where grandparents are buried. It is the place that holds family memory across generations and borders. When I sit with a family in London, the United Kingdom, I do not begin with a legal analysis of title. Obviously, I'm a non-lawyer to begin with. I begin by asking about their connection to the land. What does it represent to them? What stories did their parents or grandparents tell about it? And who is buried there? These questions are not just, rapport building. They are substantive because the resolution must honor these attachments if it is to be durable. Similarly, I invite parties to consider the spiritual dimensions of the dispute. For observant Muslims, there is a profound teaching. The one who forgives for the sake of God will be honored by God. The one who insists on their right at the expense of family unity carries a heavy burden. These are not abstract concepts. In my experience, when parties reflect on the spiritual cost of prolonged conflict, the broken prayers, the estranged children, the bitterness that consumes them, they often find motivation to settle that no legal argument could provide. And the fourth pillar is lawful outcomes. Finally, the framework ensures that any conciliated outcome is both durable and lawful. And durability means that it must hold over time across generations. I have seen too many family agreements fall apart because they were informal or because one party later claimed coercion, or because the next generation was not consulted. In the context of Punjab in Pakistan, the recent provincial governance interventions have been transformative. When parties know that their agreement can be registered with the land revenue authorities, that it can be reflected in official records, that there is a state-backed mechanism for enforcement, they now have confidence to settle. This is what I mean when I say these reforms provide light at the end of the tunnel. For families in Canada, in the UK, in America, in Europe, or Japan, or Australia, this now means that they no longer have to choose between pursuing endless litigation from abroad or relying on informal arrangements that may not hold. They have a pathway to a lawful, registered resolution that restores their land rights while mending family ties. This is the framework I bring to these disputes. It is grounded in the Islamic principle of Sulh, but it is also practical, structured, and responsive to the specific challenges of cross-border, multi-generational land conflicts. Now, the government of Punjab in Pakistan has introduced new provincial governance interventions that create conditions for this kind of conciliation to function effectively. These policies, focusing on land record modernization and accountability, are now providing a light at the end of the tunnel for these families. For the first time, when I speak to a disputing party in Canada or the United Kingdom, I can point to a state-backed process that supports restoration and conciliation, not just litigation. To help us explore how this framework intersects with governance and legal systems, I am joined by two exceptional discussants. First, Mr. Wasif Majid, a Pakistani advocate and partner at Lexium Law. Wasif serves as an expert arbitrator for the Pakistan Stock Exchange and an accredited mediator for the Lahore Chamber of Commerce. He brings the critical on-the-ground legal and institutional perspective. And second, Ruth, a research fellow at the International Food Policy Research Institute. Ruth's transdisciplinary work on property rights, collective action, and natural resource governance in South Asia and beyond will help us connect these family disputes to the broader themes of environmental peace building and sustainable land stewardship. Wasif, let me turn to you first. Wasif, thank you so much for joining us today from Pakistan, I want to ask you that from your dual perspective as a legal practitioner in Pakistan and working as a mediator and arbitrator, you see the formal system and the community-based efforts intersect every day. My experience with these expatriate families is that the new provincial governance interventions in Punjab, Pakistan, like the modernization of land records and the push for accountability, have been a game changer. They provide the state backbone that makes Sulh viable. From your vantage point, what are the critical points of intersection or tension between these formal court processes, the recent provincial reforms, and the community-based Sulh processes? How do you see them working together, and what challenges remain?
Yeah, thank you, Imam Ibrahim. Hello and good morning, everyone. Thank you, Ibrahim, for the brief introduction, but I will just briefly introduce myself a bit more. So my name is Wasif Majid. I am an advocate based in Pakistan, Lahore, Pakistan, Punjab. So it's a province of Punjab. I'm based in Lahore, Punjab, Pakistan. So I've been practicing law in Pakistan for almost 20 years now, and my practice revolves, it's primarily dispute resolution, but I have interest in ADR as well. So I am the co-founder of CIArb Pakistan branch in Lahore, and I am also the ICC YAF representative for Pakistan. So we're doing a lot of work on ADR in Pakistan right now, and we are also in the process of setting up an ADR center here in Lahore, Pakistan. So coming back to your question, Imam Ibrahim, yes, you rightly pointed out the government of Punjab here in Pakistan has recently introduced legislation that enables the dispute resolution regarding land ownership and land inheritance here in Punjab, Pakistan. And I would in fact start with your core principles that you just outlined about the power imbalance. So what this legislation right now has done is try to address that power imbalance. You've rightly pointed out that the disputes here in Pakistan, where one of the parties or the parties are based outside Pakistan. So distance creates a lot of power imbalance. The parties who are in possession in the land have more power than party who is sitting overseas, maybe in Canada, maybe in US, maybe in the UK. So they have this power imbalance really deteriorates their situation in dealing with the land disputes. And as you've said, that land is not only in Pakistan, it's not about property, it's about identity, family, you can say it's family recognition, it's inheritance, it's patrimony, everything. So land is not only property here, it's property and patrimony both at the same time. And people have a lot of emotional connection with the land. So they want, if they have any disputes, they genuinely want to address that dispute in the best possible manner. But due to this power imbalance of distance and maybe ownership disputes, they are not able to address that properly. So what the government has now done is they have intervened and they have now created government sponsored dispute resolution committees at every district level here in Punjab, Pakistan. So for that matter, what has to be done for an overseas Pakistani, they have the option to register their complaint about illegal dispossession, their inherited land, if there is any, if there is, there is the possession is they have been illegally dispossessed, they are not in possession of their land, or someone is disputing their ownership, their inheritance in the land, they have been given the option to register a complaint online, sitting back in the Canada or the US. And once they have registered the complaint online, then that complaint lands with there is a dispute resolution committee, which is headed by the principal government officer of the district. And then it has members from the local police, and then they have members from the private sector. So once they have received the complaint, they call the respondent parties. And in the first place, they try to settle that dispute amicably between the parties. So that process goes, that may be that the overseas parties have been given an option to attend that meetings even virtually. So once that committee, this high-powered committee, that leads to a successful result, then then they give their recommendation to a local tribunal which has been created under the law, and that local tribunal then records that agreement between the parties and passes a judgment on the basis of that, and that recognizes that settlement between the parties and gives legal effect to that. So that has really transformed the disputes over the inheritance land here in Pakistan to a larger extent. It has been working efficiently since its introduction in the last 1 year. There have been a bit of court challenges to that process, but overall the mechanism that has been introduced by the government is working efficiently, and people are finding it very useful to have their disputes settled in the first place amicably. And then if it's not, even that law provides, if the dispute is not settled amicably, then it goes to the tribunal, and the tribunal is a very fast track tribunal which which settles the dispute between the parties within a 90 days period. So that is helping the parties, that overseas parties, they have been given a right to have their dispute settled at the earliest possible manner. You are mute, Imam.
Thank you so much, Wasif, for that detailed analysis of the current mechanisms that now exist. And like I said, I like to call it light at the end of the tunnel for overseas Pakistanis. Um, and I think it's wonderful to see that now, after several decades, that finally there is really hope and optimism. And I actually see that a lot of overseas Pakistanis now are really interested now in now, they're taking an interest now after several decades in these ancestral lands, and this I also believe that will enable their children who, like I said, there was a distance, or there was you know, because of the disputes and because of the complexity of these disputes. But now, hopefully, this will enable even the future generations of these overseas Pakistanis, and their children will also take a vested interest in this land, just to make sure that this land is obviously, um, you know, um, taken care of, and so it can be an asset for the environment. Um, Ruth, your research on collective action and property rights globally gives you a unique lens, and in particularly in these type of generational land disputes that we are discussing today, which are often complicated by absentee ownership and gender dynamics in an inheritance. What institutional or governance dynamics do you see as most critical? Specifically, how can a process like Sulha, supported by accountable state mechanisms, contribute not just to family peace, but to sustainable land stewardship and preventing future cycles of dispossession?
Well, thank you for the opportunity to attend this even, and then to engage in the discussion of this fascinating approach. As you mentioned, I've done a lot of work. I'm coming at this from the social science perspective, as opposed to the legal or the more theological. But I've done a lot of work on legal pluralism. And in that, we think about how each social field generates its own law, where law is not just formal law, but also its own set of rules. And what's fascinating about this case is that you have so many of these social fields here. You have Pakistan and Canada or the UK as national entities. You have this Islamic social field. You have a lot of customary law, which, as I understand it from within Pakistan, might be different for different groups. And then also, family creates its own social field. And then you have the villages and communities, both in Pakistan and abroad. that generate their own sets of rules. So navigating that is really complex. And I think the through line in that you've identified is the meaning of land in those different social fields. And it has both, a livelihood and an economic value, as well as this identity, heritage, honor. And then finally, what I'll probably come back to more is this issue of the social connections. And it's not only a conflict of interest, but a conflict of values. What I really like about what you're doing is that your approach of looking at not just the interests, but at justice and what is feasible. And appealing to both law and formal law and Islamic law and to values. And recognizing the spiritual, emotional, and relational aspects. What you said about the importance of acknowledgement, that's the core of the Truth and Reconciliation committees that we find, certainly in South Africa, but elsewhere. I think that's got, and what I was reflecting on is the applicability beyond Pakistan here. Now, all over the world, you probably get inheritance disputes. I know of many in India and US and others. And they're either because people value things for their economic value or their sentimental relations over their relationships with living people. And I think it's important to acknowledge, each of these. And this, coming back to how this can affect natural resource management, is we see many communities that have had, even whole communities that have lost their land. And reminding state authorities and others that it's not just the economic value that matters, that you have to look at these multiple values. But also what I find interesting about what you're doing is that you use and you explicitly recognize the different types of power and resources, but you use those values as a way of finding common ground and bringing people together. And I think that I just find so fascinating. What you said, that, tell me about the land, is a starting point that isn't just a warm up, but that's fundamental. I think don't know enough about this and still reflecting on it, but how this reconciliation approach could be used even for communities to claim lands that they have lost in various countries, or that they've had over generations and somehow are not being recognized. So this whole approach is fascinating, and I really appreciate you bringing this to a broader audience and thinking about how we can apply this systematic approach. Thank you very much, and I look forward to more of the discussion.
Thank you so much, Ruth. And Wasif, I'd just like to quickly bring you back here. And my question to you is that what is your experience and what are your observations, given that these new reforms are now something that have been institutionalized in Punjab, Pakistan? What do you see in terms of the shifting, in terms of the willingness of the parties to engage in this Sulh process that the government of Pakistan is promoting? In my cases, when families in the UK and Canada see that there is now a lawful path to restoration, they become more open to conciliation. Does that also match your observation, Wasif? Do you see that they are the parties are now open to, engaging in the process.
Yes. Thank you, Brian. So what there are now two pathways to claim your ownership or your possession back to the land. Either you adopt the conventional litigation mode, in which you have to go to the court, you have to prove your right, and you then get a judgment and then enforce that. So that is one conventional method of claiming back the land and the ownership or the possession of the land. Then this is now the second pathway that has been instituted by the government of Punjab. But what that has done is that has mandated mediation before you go to a specialized tribunal. So you still have the option to go to the conventional litigation, but obviously that will come at a cost. That might come at the cost of your family ties, that might come at a financial cost, that might come at a time cost, which you like overseas Pakistanis and communities are, so they don't like to do that. So what this fast track process has given is that they have given them access, or they have the option now to go to a specialized tribunal. But before doing that, they have to enter into a mandatory mediation process. And that mediation will be conducted by a high-powered committee that has been formed by the government itself. So that has done something which is uh, even in conventional litigation in Pakistan, we don't have a mandatory mediation concept. So that is still optional. But that provides a fantastic opportunity to the overseas that now they have a mandatory mediation process in place that not only helps them to resolve their disputes and sort of protect the family ties. So they have also the benefit that in case their mediation fails, they will have the option to go to a fast track tribunal. So now parties are more willing. A lot of people, our clients, are coming up and asking us about how we can approach this committee, how we can do, how can we benefit from, how can we reclaim possession under this law. So this has changed the dynamic of how land disputes, or in particularly the inheritance disputes in Pakistan or Punjab, they will be dealt. And in future, we see a lot of mediations that will be going through this new framework. So we are very optimistic, and we see a lot of positive things coming out of this law and out of the mandatory mediation process that has been in place in Pakistan.
Thank you so much for the insights, Wasif. Coming back to you, Ruth, and to build on what we've discussed, I wanted to ask you in terms of the role of external facilitators like mediators or Sulha practitioners or mediators in navigating the interface between community-based dispute resolution and formal state systems, especially in contexts where there has been a long history of state capture or weak governance. How do you see the role of these mediators or external facilitators?
Thanks. That's a really good question. Where they can be um, where they can be found or trained, I think that's a really key part. And even in, for example, in Africa, places I know where there's been legal reforms, getting the um, community-based legal assistance kinds of facilitators to make that bridging is really crucial. What is challenging is how do you find them, and the crucial point of trust. I think especially you've been able to use the Islamic principles as creating that basis of trust. And I think looking for what, so that the people who come in, sometimes it's an external NGO and they will be trusted because they're seen as not vested in either the formal state or the community. But again, having that, but knowing enough of the community perceptions and rules is the tricky part, which is part of what's so exciting about what you're doing is how you create that when you're bridging such broad differences.
Thank you so
Imam,
much.
I
Yes,
just wanted
please.
to mention to the audience members, if they want to put a question in the chat, they can certainly go ahead and do that. So we can invite any of the participants to join the conversation.
Thank you so much, Elizabeth. I just wanted to say that this has been a very rich conversation, and I just wanted to quickly synthesize a few key threads that have emerged before we start answering the questions. The first is that we've heard that the state's role is critical, but not as a direct adjudicator. And the new Punjab governance in Pakistan, the new governance interventions provide a backbone, a credible record, and a lawful pathway that enables community-based processes like Sulh to function. And we need more of this across the world. This is what gives families the light, that light at the end of the tunnel. And second, the emotional and relational harms are often the primary barrier. And my own experience with families who had been, estranged for decades confirms that restoring dignity and acknowledging past wrongs is often a prerequisite to resolving the land itself. And Sulh, when it's done well, addresses this in a way litigation can never address. Thirdly, there is a direct link to environmental peace building. When land is contested, it is often degraded, left fallow, or exploited. Resolving these disputes through Sulh or similar processes, faith-based processes, or any cultural-based processes that are effective can lead to sustainable stewardship, which benefits not just the family, but the broader community and ecosystem. So we'd like to open the floor now to your questions. You can use the Q&A feature to submit your questions, or you can even send any questions that you have in the chat, and we would gladly answer any questions. If any of the esteemed leaders who are in attendance, I know Carl, Karishma, even Elizabeth, or even from the discussants, if you have any questions, please feel free to. I have a question for you, Wasif, and I know this maybe I get a bit off topic, but what is it? What is the fascination of Pakistani advocates and the black tie and the black suit? Is this something that they always wear? Because every time I see, advocates or attorneys in Pakistan, you always see a black suit and a black tie. Is this some kind of, is it a more is it like a fashion, or is it just something which is uh you know something that has been going on? Do you think there'll be any changes with this?
We hope and we promote that this should be changed, but unfortunately, we are still stuck with that. And I will quote something that interesting that happened maybe a couple of years ago. One of the lawyers who, in fact, petitioned the High Court here in Pakistan to have this trust change at least during the summer weather, because here in Pakistan it's very, very hot during the summers. It touches sometimes around 45 and between 50. So one of the lawyers petitioned here the Supreme High Court that this should be changed at least for the summer weather. And I was incidentally sitting in the court at that time, and I was listening to to the arguments. And the judge dismissed that petition with the observation that you've come to the court just for cheap publicity. So we are still stuck with that, but we hope, and we promote and we propose that this should be changed at least for the summer. So for winter it's okay, but not for summers. And in Pakistan, Ruth has been in Pakistan and she knows how hot it gets during the summers.
Thank you so much. So we have a question from Hagar. Thank you so much for your kind words, Hagar. The question is, how do you deal with parties? As was discussed, sometimes getting the parties to sit at the table is one of the most difficult challenges when trying to resolve these disputes. So the question is, how do you deal with those parties that refuse to sit at the table or leave the conversation? Uh, and is this a common issue? So, Wasif, if you would like to maybe, if you like to maybe say a few things about this, if you would like to answer the question.
So I can answer it in the context of the recent framework. As I've said, now they have mandated the mediation. So if you want a fast track resolution to your dispute, inheritance dispute, land dispute, then you have to have that mandatory mediation session. And if you refuse to do that, then you have to go to the tribunal and you have to follow the conventional method to claim the land. So that at least in Pakistan it is now there's a legal instrument, legal backing that forces parties to continue in the mediation process. Because if they refuse to do that, then they will be going to the conventional litigation method, and that will be a very prolonged activity. So that at least in Pakistan now, they have the incentive that if they continue with the mediation, they will have to have that dispute resolved at the earliest. Otherwise, they will be forced to take the conventional mode of litigation.
Thank you so much, Wasif. And like I mentioned earlier, like caucusing and meeting the parties in these disputes, it's a lot of the work as the mediator, the facilitator, is to meet with the parties separately. And it's a lot of discussions, private discussions, where you and a lot of the times it's sometimes the parties don't even sit at the table together. It's a lot of the mediator has to, in a shuttle process, guide the parties because the conflict is so deep, and the parties are in the process of triangulation. There's so much entrenchment that it's really, I mean, there could be violence, there could be serious consequences if you were to bring them together. So the best way is to use shuttle methods or just to communicate with them privately and try to bring forth a resolution that way. So that's something that I would propose, is that talk to the parties separately, use caucusing, use the shuttle process. um, Another thing, another important element that I have, and I want to bring it over to you, Ruth, is I'm very interested in how, for several decades, there have been issues where, uh, women in particular, they have not been granted their inheritance rights, and in particular to these land disputes. In Pakistan, it's very common in other countries as well, where it's also very common where like the brothers they take the sister's land, or the sister is not interested for whatever reason. So there's a lot of injustice that happens there. So from your global perspective, Ruth, on gender and property rights, um, how do you think we need to raise awareness for this? Or how hopefully now with these mechanisms that exist now, women who feel that they were not given their right can now come forward and claim um, the land. But a lot of the times, what's also happened in Pakistan prior to this new mechanism, as you know, Wasif, is that people through illegal ways and illegal methods wrongfully were able to possess that land, whether it's through bribery or through other means. And a lot of the time, sometimes even if the sister is coming forward now and saying that this is my land, it may not be in her name. So there's a lot of things, but there are a lot of people I know, females and women in particular, who they may not necessarily want to even initiate a claim or start a process for reconciliation, but they feel that something that belonged to them or something that was their right was taken away from them. So is there anything you'd like to add about that, Ruth, and how can we address these things, and how can we really help these um, victims at least feel that they have a process and they should kind of not just let this go in vain?
That's that's a really interesting point because where earlier I said that often the relationship aspects of land are underplayed. In the case of women's inheritance, that has often been played very strongly, that it's more important for you to have a good relation with your brother than for you to have land yourself. And also, if women were leaving the area, marrying out of the community, they couldn't physically manage it. You've talked about the importance of the sort of power relations of just being there and being able to manage it. So I think it's interesting that for women, there's been playing up the relationship rather than the land, and the quid pro quo was often the assumption that if something goes wrong in your marriage, you're always welcome to come back here and your brothers will take care of you. when that falls through. One of the things we have seen helping in this is to convey not just to women, but to whole communities why it is important for women to have secure land rights. And that it's not, we find over and over that where women's empowerment and the idea of dominating over men is seen as like a no-go. When you show that women's empowerment is good for families, it's good for not just the women, but for the whole family, then that creates the opportunity. Now, how to play that out with the transnational movement of women, I'm not as sure about, but I think there can be something again that shows, well, when you have um, when the woman has rights, she is still vested in that community and contributing to it in some way. So playing up the not the sort of zero sum, but the benefit of women's empowerment and land rights in particular as a good thing for more than just the woman herself is a starting point that we've seen helpful in some contexts.
Thank you so much. It reminds me of some African proverbs, like if you educate a man, you educate an individual. If you educate a woman, you educate a nation. And I think we definitely need to, um, raise more awareness about this, especially given the fact that, this is something that has existed. And Wasif is also aware of this. And it's something that a lot of the things sometimes in certain communities, things often are brushed under the carpet for several decades. And it's, there's so many people who have even passed away, some women, and, they just were silent. And I think we have to ensure that we are always, especially when we're talking about environmental peace building, we have to make sure that, we are always, speaking, about these important elements. I want to pass it now. I want to thank you, Ruth and Wasif. I also want to thank the Environmental Peace Building Institute and MPACS and everybody who's really worked together to put this event together. And I want to now pass it on to Elizabeth um, to give us the closing remarks.
Yes, I want to just say thank you to every participant. I think this is such an under-recognized and useful tool is using faith to bring about peace and mediation and discussion. And particularly as we see, we study especially at NPACS, the impacts of armed conflict and forced migration. And we're going to be facing a lot of migration in the coming years through climate migration, forced climate migration. So this can only grow and as far as these kind of conflicts. And so this is a very useful tool. And I just wanted to, before I forget, I wanted to tell everybody watching this or in the audience here that we have the links in the chat to NPACS if you want to become a member, our conference, to the path to recordings of past and then links to future events for the Environmental Peace Building Association. But I think we've gone over the hour, so I probably won't say too much more about that. But please check out our links and the organization. And if anyone else has anything for just 2 seconds, otherwise I think we'll wrap it up here. So thank you so much. And I think that's been a wonderful discussion.
Very much.
Imam, any
So
last words?
much. Thank you so much. I just wanna, end by saying, God bless everyone, and we pray for peace, and we pray, that peace prevails across the world. And I want to thank everybody, whoever's, especially Carl as well. I know he hasn't said much, but he has a lot of insight. He's a very wise leader. I want to thank Karishma, everybody who's part of this, you, Elizabeth, and Ruth, and Wasif, and all the participants. And we hope that this session today will provide light at the end of the tunnel for many who are navigating these disputes, or those people who can help parties find peace and conciliation. Thank you so much again,
Thank you.
and we look forward to future discussions as well.
Thank you.
Thank you.
Yeah, this was great.